Thank you very much. And thanks to Sandra, who's left us now, for her introduction to country. And I too acknowledge the Noongar people and the contribution that they've made to the history of our land. Indeed, Sandra raised the issue of names. And one of the joys I had as a local member of Parliament was exploring the various names that existed in the electorate of Victoria Park. And I must say I aspired to be a member of the Geographical Naming Committee. I reckon that's one of the better ones in Western Australia. But you can go to a name and then you get a whole history surrounding a name, and you can build stories and you can teach young people. And so I was delighted that Sandra did focus on that in her Welcome to Country. I wrote a history of every suburb in my electorate, which went out to all of the various new electors that came on, following some research I did in the wonderful Batty Library in Western Australia. And looking into the Aboriginal aspect of our history wasn't easy. Getting references, there were a few references to locations in and around the Causeway and in and around East Victoria Park that had significance. But there was one fascinating issue that came up, and that was that the suburb of Wilson was named Wilson, having previously been named Beeloo, which was the Aboriginal name. We heard Belier, the Swan River. Beeloo was the name of the district here, and there was quite a significant character called Mundy, who played a role in the relationships between the settlers and the Aboriginal people. But I received a wonderful letter from the Wilson Boy Scouts or Sea Scouts, and they said, "We've read your little pamphlet on the history of Wilson, and we want to change our name to the Beeloo Sea Scouts group, because we're going to use that as a means to educate our young scouts into the Indigenous history of Western Australia." So Sandra reminded me of that, the importance of names, the importance of building stories around those, and congratulations finally to the Western Australian Public Service, the Western Australian government as it was then, the Barnett government and the opposition, for the wonderful agreement that's been entered into with the Noongar people of Western Australia. It's a first-class agreement settling a lot of issues, and I know that the Public Service played a significant role in developing that. So thank you to the Public Service. Thank you to the Public Service generally for the role that you play in our society. And can I commence my talk by pointing out how important that role is. In the eastern states at the moment, and certainly here in the west as well, there's a major fire emergency. The services that are available to deal with that emergency, public sector services, backed up by a whole range of volunteers. You know, people can talk about fat cats and all that sort of language, but when the crunch comes and civilisation is at stake, a good public service is absolutely fundamental to that. And in whatever work that you do, I think it's important that we acknowledge its importance in the overall outcomes that we have in our community today. So, what's my topic for today? Freedom of information is one part of a much bigger story. And the bigger story is the story of open government. A people's right to know, and of course a people's right to be involved. Two very important principles in our system, which are packaged together under the heading of open government. And freedom of information legislation is one part of that story of open government. And so I think if you're interested in working through the details of your job as a FOI officer, or you're a chief executive, or you're in Catherine's position, you need to know about the background and the theory and the philosophy of open government and why it is that that's an important principle in our particular system, and how freedom of information can back it up. But when we talk about open government, we're not just talking about FOI. We're talking about the writing of history. And there's an interesting debate going on in Canberra at the moment as to the sort of information that should go into a history of the Australian military involvement in the Middle East. Highly political issue. Should it be put out there and part of the history, or should the Defence Department have the ability to say, no, some things are best left as secrets? We have it every time the media asks a minister about a particular issue, whether or not the full disclosure will come, or whether just little tidbits will be thrown out there for various reasons. The police often have that challenge because, you know, they've got an ongoing inquiry going on, they're being pressed by the media, and you know, they just want a little bit more time to actually solve the problem or find the culprits, if you like, before they talk too much about what they're doing. Because one thing about the criminal class, they're usually, not all of them, some are as thick as a brick, of course, but some of them are actually quite smart. And then there's all of the issues associated with day-to-day government and whether or not information should be put out there. But backing up this, we've developed freedom of information. Fascinating to see the history of it. Obviously the Scandinavians were in there very early in respect of this idea to have a right to know about what's happening in government, and have systematised it so well now that their proactive disclosure is very, very powerful. I'll talk about that a bit later in the talk. But in our terms, really post-war, even into the 80s, we started to develop this idea. I remember in the Lawrence government, we debated this issue back in the early 1990s. And my good friend, the Honourable David Smith, who was our attorney, introduced the freedom of information legislation into our parliament. And it was an important breakthrough. But, you know, I'm not uncovering any secrets. It wasn't an easy road for David to get that into the legislation. And you'll understand, of course, that there are those who are not so keen on extensive freedom of information legislation. So it's a recent development. And I want to put some context around that development in my talk today, which I hope will assist you in understanding what it is that you're doing as an officer in this field. The theme I want to put forward is a pretty basic one. This is a challenging business for the decision maker. A challenging business for the decision maker. Character and judgment are required. I mean, this is one of those areas of public administration where you're asked to make a decision. And even, you know, many of the other agencies of accountability, they advise. They don't necessarily have the power of decision, they advise. And the executive arm of government may say, well, that's a great report, but we, you know, for various reasons are not going to do it. You make decisions. Those decisions, of course, can be then go up the system and ultimately might find their way into the judicial system. So I want to emphasise that character and judgment are just as important as what we might call knowing about what the law says and the way it's put together, because the law is inviting judgment. It's not giving you an easy way. It's inviting you to make a judgment call about something. And there's a wonderful quote I found, interestingly, in an article on educating politicians. And it pointed out that the ancient Greeks, who had a very strong concept of citizenship, in fact, the people, didn't include women or the slaves, we must acknowledge it at that point, but the people of Athens, for example, could play a direct role in the government of their country, or their nation, their city-state, I should perhaps call it. And that meant they needed to be educated. And when they dealt with the educational side, the values underpinning the system were a crucial part of that education. And I think I want to emphasise that it's your character and your judgment that's really at stake here. And I've got a quote, I think a wonderful quote from Professor Cameron, who wrote about the Greek method of educating their citizens to be potential legislators. Perhaps we have grown too fond of the false dichotomy between a government of laws and one of people, and have forgotten that laws do not enforce themselves, but are enforced by people. A brilliant quotation, I think. There's the law, but in the end, the law has to be interpreted and has to be delivered. And that can be very tricky particularly when you're dealing with decision making where there are competing interests, which of course is exactly what we have in this field. So that's my theme. Character and judgment have to be part of this story when it comes to considering the question of freedom of information. Right, now let's look at the ways in which people think about government. Yes, Minister. Have you all seen the Yes Minister? It's still going. It's still going. Unbelievably well written. And of course, you might remember the episode when Sir Humphrey was talking to Sir Arnold, you know, having a sherry. I was thinking about England, they always have sherry. I never quite worked this out. Dry sherry wasn't too bad, but the sweet one, not good at all. Anyway, Sir Humphrey's trying to get advice from Sir Arnold, who was his predecessor as the head of the Cabinet Office, chief advisor to the Prime Minister of Britain. And, you know, how far can this openness go? How far can it go? Well, Sir Arnold had an answer to that question. Open government is a contradiction in terms. You can be open or you can have government. So that's one way of looking at it. One way of looking at it. And the particular episode is on YouTube. That where you get that quote. It's a fantastic episode of Yes Minister. So that's one way of looking at it. Here in Western Australia, of course, we have the alternative method outlined and described brilliantly in the second report of the Royal Commission back in 1992. It's a very good document about what are the principles of our system of government, and in that document it says openness in government is the indispensable prerequisite of accountability to the public. It's a democratic imperative. So you either have government or you have openness, or openness is an imperative. Two positions. Now I would argue to you that these positions, you can just say they're prejudices, they're what you should have inside you when you're considering these issues. If you're Sir Arnold and Sir Humphrey, you'll say the first point of call is exempt any document from disclosure. That's your first point of call. If, on the other hand, you're of the imperative point of view, your first instinct is to let it go out there. Now, underneath those two things are two theories of government. And I think it's important that we understand this. The first version of our Westminster system of government is really focused on elections. Why do we have elections? We have elections to find out who's going to be in our legislature and who's going to be our government. The elections give legitimacy, and the executive has the responsibility to deliver. Now, this system, Westminster system is not without its accountabilities. It's not without it's the understanding that the government of the day is still accountable in a certain sense. But that comes from the Parliament and the very important privileges given to members of Parliament to carry out their duties. Question time, committee system in the Parliament. It comes from the police and their powers to investigate and to hold to account those who break the law. And of course, occasional inquiries, royal commissions, judicial inquiries about an issue that gets out of hand and the government needs to go further with openness than it normally would. But you can see in that version, the emphasis is on the elections. That's what delivers accountability. Every 4 years in WA, it used to be every 3 years, you have an election. And that's a crucial thing. So this version of government is all about getting things done. That's why you have elections. They legitimise the doers, delivering for the people who vote in a majority to have that government. Confidentiality, making sure that that what happens within government is within government. Ministerial responsibility, in as much as there's going to be a mechanism to take what's happening within government to the community, it's done by the minister. I mean, the notion that we have today where the public servants all line up at the expenditure review considerations with public accounts committees, etc. I mean, not part of that system. The minister is the one that answers, and the minister says whether something's going to be said or something's not going to be said. And there's a theory, electoral democracy. Now, this particular model of Westminster came out of the Second World War. It meant democracy as electoral democracy, and elections as opposed to authoritarian systems of government. Remember, the Second World War and the post-war period, democracy was under challenge by those who didn't want to have elections. One-party rule was the case, or the fascist version or the communist version. So that's one theory of government that exists, and I can assure you that theory of government has been subsequently changed, and I'm going to go to it now. But in the minds of people where it matters, that system is still active. It's not the system, but some people still see that as the best system. The alternative, of course, is what John Keane, the professor at Sydney University, has called monitory democracy, going beyond electoral democracy. Power is given to people from the election, but we have a whole lot of agencies that are there to make sure that power is not abused, or to attempt to make sure that power is not abused. Look at the list. Auditor General, Ombudsman, Information Commissioner, Public Sector Commissioner, Inspector of Custodial Services, Corruption and Crime Commission, Parliamentary Inspector of the Corruption and Crime Commission, Commissioner for Children and Young People. And they're all in there as part of our system. They're part of the executive, but they're independent from the cabinet in the way that they carry out their functions. So we have added to the Westminster system all of these particular agencies in order to make sure power is not abused. And so there was a historic development. You can see elections came first. We established electoral democracy. We recognised that just because the majority are ruling doesn't mean that that's the end of it. They can do what they like. The great John Stuart Mill had pointed out in his famous essay on liberty that there could be a tyranny of the majority. What about the minorities? What about due process? What about a proper consideration of all of the issues that matter when you're considering a public policy rather than just one of them? And so we needed new institutions to come in. And they've come in now, and one of them is the Information Commissioner, another is the Auditor General. Well, the auditors were always there, but their role has, I think, been uplifted in terms of what they can do, particularly through performance auditing, which has now become a much more established part of what they do, rather than just looking at the books. You're going to have a little debate in Western Australia over the next few months, I should imagine, about whether we're looking into the books closely enough. You know, it's a challenging question. All jurisdictions have had it. They had a big issue in Victoria with their education department. You might recall that case. So that's going to be an important question that's going to be... So what are the themes associated with this system? Getting things done properly. Not against getting things done, but getting them done properly. Due process, transparency, trust, monitory democracy, monitoring what the executive is doing. I had a good lesson early on in government, very good lesson. I was Minister for Education, and the department came to me early on. The lady's name was Margaret Nardebaum. You remember Margaret, the head of the education? And she said, look, we need a proper process in place to deal with school closures because, you know, populations are changing, demography, we need to close some schools. And we set up the process, which involved, you know, consultation and whatever. And then they advised me that one school called Carmel School up in the hills, I think there's very few children there. It was a junior primary. We didn't have many more of those in our system. It should be closed. But the parents there didn't like that idea. So they engaged who offered his services to the very free, one of our best lawyers, who then went into bat against the minister's decision, which was me. And so I'm sitting in the Supreme Court getting grilled by the lawyer about when I made the decision, how I made the decision, whether the... And the fact is we'd followed the proper process. And the implication was of the critique of the lawyer and the school community was that I hadn't. But the point here is simple. I needed to. The judge in the case was Justice Ip, who you might remember, who went on to become the head of ICAC in New South Wales, a wonderful contributor to our system. I often quote this case because he said I was a very reliable witness. I thought that was wonderful. The West Australian Education Department won the case. Lesson. Follow the process. I mean, it's not... Margaret Nadabaum, she knew about government. She advised the government what the process should be. We did it. That's good public service. And that's what ministers need so that they don't go across into a pathway that'll end up in either, severe political difficulty or at a minimum level, failure in terms of what they want to do. And so they're these two theories. And when we think about freedom of information, they're up above it all. They're there all the time. And I want to introduce you to an idea that I've developed in another conference that I went to about this particular issue of public interest, and published in a book last year. That when you look at government, you can say there's Labor, there's Liberal, there's the National Coalition, there's some independent members, there's some small parties, and they're all in there having a fight, about what should be done and what shouldn't be done. But what I'm interested in is going down a bit deeper. Who's there? Who's really fighting out these things? Because to me, the fights within the parties can be just as important as the fights between them. And the fights within them, interestingly, occur around a lot of these issues that we would call accountability issues. They also occur around outcome type issues. You have what I call the business and productivity party. Let's get on with it. All these checks and balances are stopping us create jobs. I think I heard someone say that yesterday. I don't know who he was, but he said that. And the sustainability party, slow down, make sure you consider the economic issues, the social issues and the environmental issues, so you come up with a good judgment call in the end. So let's get things done versus, on the economy versus sustainability. But on process, there's also a division. The power and control party versus the integrity party, if I can use that expression. And I think that's an interesting division as well. And I've sort of mentioned the book chapter in which I talk about that. Tom Frame, who's an interesting man. He's a professor of politics and an Anglican minister at the same time. He's he wrote a lot of books on military history and on political philosophy. Balancing competing interests within the public sector was my topic, and I made this distinction between the integrity party and the power and control party. Now, I mean, all of you know this difference. I don't know whether I even had to tell you. I'm sure you see it all the time. It's there, it's in the system. The power and control party puts its focus on whether or not what government wants is happening. Their interest in public sector matters focuses on the appointment and dismissal of government, their capacity to create a coterie of political advisors, and the need for the centralisation of political and bureaucratic power rather than its devolution. They are interested not just in what is happening within government and how that is communicated to the outside world. It follows that information management is accorded a top priority in the way they arrange their affairs. Now, I'm not talking about Catherine's information management here. I'm talking about information management so that the right spin goes out into the community, which, of course, governments have to sell their story. They have to. And so power is their motto. Power is their motto. Media management a key principle, and the cabinet, the executive, is their base in government. Then you've got the power and control party. You've got alongside them the integrity party. Focus on process, but from the perspective of ethical practice and the avoidance of conflicts of interest. They want codes of conduct to clarify what's right and wrong. Those manuals that are produced as part of the legislation. They want the monitoring of activity within the public sector by independent bodies with wide powers of investigation. Integrity is their motto, and they see efficiency and effectiveness as important, but not at the expense of due process and public trust in government. The need for control is understood too, but not if it leads to a blurring of the important distinction between party and state and the creation of inappropriate networks and partnerships. They have strong support within civil society, particularly the legal fraternity, but need to translate that support into adequate funding from government and a robust mandate from the Parliament. So they're the two interests, if you like, that are always there, underneath perhaps, not even declared, but they're there in the system at any point in time. Now, let's go to freedom of information and look at how these differences play out. Let's put ourselves into the position of the minister or the agency. Surely, you can see them making this plea. Surely, we need some freedom from scrutiny. Not because we're bad people, but we want a bit of time to think things through. Not an illegitimate consideration, a tricky one to apply when it comes to FOI, I acknowledge, and we'll come back to that. But having been there, it is true. I don't think we want more thinking in government and less doing, actually. We do need a bit more thinking about what's a good policy and what isn't. Whenever I see a cabinet, I see the fundamentalists. They know what to do before they look at the facts. The vested interests, who don't tell you that they're working on behalf of someone else, but they're in there. The populists who say, whatever the public want, we'll give it to them. And then you've got your social scientists and your scientists who say, these are the facts, according to the research, peer-reviewed research that we've done. And then there's the poor old leader trying to bring it all together. So you do need time to think these things through. Secondly, surely there are some areas that are out of bounds. A very good minister in the Lawrence government resigned, as you'll recall, because he agreed with the disclosure of some information related to a building society way back in the early 1990s. Bob Pearce resigned immediately and honourably, and he was an extremely good minister, a very clever man, and he got caught by that. There's the privacy question. Then, of course, there's our government favourite, absolute favourite, national security. Can't beat it, law and order. And after September the 11th, it's amazing how many submissions have come up to the Cabinet. It's in the interest of tackling terrorism. You understand why, because obviously terrorism's a terrible thing, and it became a highly politicised issue, as you could imagine it would. In a wartime situation, the great Sun Tzu, the great Chinese philosopher of war, said the best thing you can have when you're fighting a battle is information about what the other side is doing and thinking. And so, is it good for your system to have too much going out? And finally, look, this is the frustration a lot of governments feel. Oh, look, I've got to meet this stakeholder group tomorrow, and we've got a tough issue to try and take through a significant issue on water policy or whatever, and I've got to answer all these questions about, this, that and the other, where the media are just doing a bit of, the opposition rather, are doing a bit of a search to find out whether there's something there. I've got to spend all my time on that, and I'm being pushed off track. Most of my time spent dealing with this rather than dealing with policy. So in our system, there's this caution about disclosure. It's embedded in the thinking of the power and control party within the system, if I can use that expression. And they're sort of not illegitimate points. They're not illegitimate points. But on the other side, the competing interest, and I'm using here the Queensland Act because it's amazing. They list every one. I mean, I've never seen legislation like this. It's all there. In a free and democratic society, we should have open discussion. Information in the government's possession or under the government's control, public resource. The community should be kept informed of what's going on. Openness enhances accountability. If you know that people are going to look at it, you'll be more careful in the way you put it together. Openness increases the participation of members of the community in democratic process. The right to information legislation contributes to a healthier democracy. improves public administration. And the right to information legislation is only one of a number of measures that we can adopt to encourage the flow of information, and that's where we get to all of the argument about having disclosure more generally built in. Pretty good summary of why it is we want disclosure. So you've got caution on this side and a degree of hostility, and on this side you've got all of these arguments very strongly embedded in our democratic system about why you should release information. So, two forces. Governments responsible for the information they have and its use for the security and welfare of the people. They have a responsibility to manage that information properly. And on the other side, the public who want the right to know and a right to be involved. Now, how do we find this public interest? Well, the first port of call, I think, is a general definition of the public interest. And the best I've come across is Chris Wheeler. Chris was the Deputy Ombudsman in New South Wales. He's retired, and I used to have a lot to do with the Auditor General's office, the Ombudsman's office, the ICAC, because I teach the public servants, would have these people in to speak. So I got to know Chris very well. He also did a very important review of FOI in 2009, which shaped the legislation that was introduced in that same year in New South Wales. I'll come to that in a minute. But what is this public interest? A good definition in relation to the decision-making in particular, the meaning of the term or the objective of or approach indicated by the use of the term is to direct consideration away from private, personal, parochial or partisan interest. It's pushing you for the higher good. It's pushing you away from the narrower things that might dominate your thinking. Now, for an FOI officer, this leads to the first conclusion that you need to, I think, take into account, and it's been built into the legislation around the country. In determining whether the disclosure would be contrary to the public interest, it's irrelevant that it would cause embarrassment to the government, cause a loss of confidence in the government, cause the applicant to misinterpret or misunderstand the situation. And so, you know, in other words, it's asking you to go away from your organisation's narrow interests, to go away from what you might think. We all have biases, they're all built in. We might, here goes the media again, you know, they're just making trouble. They've developed a set against my department and they're in there trying to stir things up. And these biases, of course, can get built in, and before you know it, you're making decisions that might not have been what the legislators intended when they passed the FOI Act. So this is the first part of any public interest consideration, is you. And it's sort of, it's difficult keeping the minister happy. I mean, not all ministers are, you know, high-level believers in due process. Can I put it that way? You know, some of them are, some of them not. They're all different types. That's what's good about our system in some ways. I used to do a little lecture at Sydney University to the public service. How do you deal with an idiot as a minister? And you know, there's a challenge. I did have my answer to that, by the way. There is a challenge there. Self-interest, you might not want to rock the hierarchy in the department. And there's some work done in Victoria recently on this question of, you know, what officers in local government and state government think about the system. Who's making their job hard? And a lot of them said it was their chief executives, which is, you know, is a bit of a concern in terms of the system. There's your organisational interest. I mean, you're part of a team. You know, you believe in what you're doing. You're proud of what you're doing, and people make mistakes. And isn't it awful, you know, that this little bit of information, really the public don't need to know that. So bias can be built in your attitudes to the media, and they can even become almost subconscious habits. So the first port of call for any officer is what I said at the start: character and judgment. Think about what your biases are, work it through in your own mind, and then I think you're well placed to do the job. Trouble is, the job is a very difficult one. This is what the High Court said. It's a long quote, but I'll go through it. The public interest is not one homogeneous, undivided problem. It will often be multifaceted, and the decision maker will have to consider and evaluate the relative weight of these facts before reaching a final conclusion as to the... how am I going with time? 5. We'll have to consider and evaluate the relative weight of these facets before reaching a final conclusion. And it goes on. So the public interest is multifaceted, and you've got to get in there to find a solution. My suggestion, did you watch Gillian Triggs on the TV the other night, the former Human Rights Commissioner? Made a very interesting point. She said what a lot of her critics didn't understand, she was working according to legislation passed by the Commonwealth Government of Australia. She had certain obligations under that legislation. First thing, know what the law says, and you're going to have an interesting discussion today about all of that. Occasionally it filters up to the judiciary. Know what the judiciary tells us about these matters. There are lots of people who will advise you on these matters, but the parliamentary law and the judiciary should be the backdrop to your considerations of this. In WA legislation, as you know, 9 of the 17 exempt ideas have a public interest test attached. And you've got to work through this public interest issue. Is Parliament telling us that it is not in the public interest to disclose the 8 types of documents without a test, such as legal professional privilege? And the other exempt documents, on balance, you need to find that public interest. I'm not going to go through the detail of that. You're going to talk about that through the course of your meeting. But I'm going to indicate to you what the High Court says. It's unacceptable to have a restraint on the publication of information when the only vice of that information is that it enables the public to discuss, review and criticise government action. If that's the only vice, there's no doubt about it, it's got to go out. That's what they say. Now, over this conference, I want you to consider 3 questions that I think are interesting. 1, should the Freedom of Information legislation refer to reasons for refusal rather than exemptions? Reasons for refusal being recognisable detriment or harm. Rather than having exempt in the schedule, should we just have a concept of reasons for refusal and then look at each issue on its merits? Interesting question. The New South Wales review of the FOI Act 2009 said yes. Second question, should offence provisions be built into the FOI Act? In New South Wales, the placing of undue pressure on decision makings in order to influence a determination is an offence. The decision makers who willfully fail to comply with the law is an offence. Do we need that sort of thing, or is that just going to make life harder for you? And finally, the big issue that I'm sure you'll be discussing, should more information be provided as a matter of course? Proactive disclosures, publication schemes, so that people know what they can access and how they can get it without having to go through necessarily the legal proceedings required under the FOI Act. And then there's the disclosure logs. Disclosure logs have an interesting friend and an interesting enemy. The friend is the people, the enemy is the media. Because the media say, look, I've done all this hard work, I've got a story to tell, and then I've got to let everyone know about it. And so that's an interesting question which we might discuss, I think, in the panel. And so I throw those 3 questions out. For me, they're very interesting ones that I hope you can discuss. And here's my friend, the cartoonist. Absolutely spot on. Have you noticed this? Cartoonists are always right. They're always right. I once developed a notion that there are 28 tribes in politics. You're one of the tribes, you know, the accountability officers, they're in there. Cartoonists are, because they go to the psychology. This is just outstanding. You can use this, put it on your wall, you know, in your office, and you can find out all of the ways. So, look, that's my theme. Character and judgment. Look into yourself, find out what your own biases are, work out whether they're relevant to this situation or not. And then secondly, when it comes to balancing off the forces, get them all in there and make a considered judgment. And, you know, it's your decision and your integrity that's at stake. and therefore I think, think about your integrity, number one, when you make those decisions, because you'll come out of that much happier than the alternative. Thank you very much.